G'day everyone, welcome to video 3.2.3. As I said in the last video, we'll try and keep this under 20 minutes. This is quite a big one, quite a dense one, so we'll try and whip through quite quickly and get you the key information you need. Quote for today from Susan Butcher: "I do not know the word quit. Either I never did or I have abolished it." Yeah, hopefully you're not at the point in year 12 yet where you're thinking about quitting. But if you are, something commonly I say to my year 12s, they're probably cringing at hearing it again. But it's the idea of, just don't quit. All you can do is keep turning up, abolish it from your vocab, and just keep turning up, and things will come and things will happen. So 3.2.3. Today we are looking at factors to consider when initiating a civil claim. So you feel like you've been wronged or harmed, you want to start a civil suit, so you want to sue someone. What things do you need to consider? And thankfully they give us a helpful list. Negotiation options, costs, limitation of actions, scope of liability, and enforcement issues. So pretty simple video. We'll unpack these 5 things. You'll see here that we need to analyse factors to consider when initiating a civil claim, which is a little bit of an interesting skill or interesting wording. So we'll have a look at that skill in terms of probably going to be looking at case studies. And our essential question is, what are the factors an individual will need to consider before initiating a civil claim? So imagine a scenario in which you are wronged or harmed. Okay, see if you can come up with something. Before you sue someone, what do you need to consider? Obviously, a little bit of a list in your head already perhaps, but have a stop here. If you are in class now or you're working through this with someone, think to yourself, come up with a scenario. You've been harmed in some way, perhaps you've been struck, perhaps you've been defamed, whatever. Before you sue the person who's done that to you, what will you need to consider? And we'll unpack that a little bit from here on in. So the 5 things that are listed. Negotiation options. Can you actually resolve this without going through the court system? Is what we're looking at there. Costs. How much will it cost you? Can you afford it? I mean, hopefully you're going to get the result you want, but if you don't, can you afford it? Limitation of actions. How long since the incident occurred? And this is super important because some incidents, or not some, most things legally have a limitation in terms of you can't just turn around and sue someone 5 years later. The scope of liability. So was the person actually responsible for your harm? And this comes into that cost thing a little bit as well. Like, are you actually going to be successful here? And finally, enforcement issues. Can/will they pay? And can you go through the process of forcing them to pay? So starting off with negotiation options. And this is super key. And this comes up in skill 3.2.9, I think it is. Or maybe 7, which is different methods of resolving civil disputes such as mediation, conciliation, or arbitration. So this is, can you resolve your issue without actually going to court? Because we know that court costs a hell of a lot of money. The outcome is going to be one way or the other. There's sort of no shades of grey. So can you actually, sit down with the person, talk through your dispute, talk through the fact you've been harmed, and work on work towards a resolution, I suppose, an outcome that both parties will be happy with. You can decide on whatever rules you like with the person. You may have a legal representative doing the negotiating on your behalf, whatever works. But can you actually resolve it without going to court? And if you can, it's generally the best option. The second thing to consider is costs, and simply how much will it cost you? We know from the criminal justice system how expensive having to defend yourself from a criminal charge can be. And it's exactly the same if you're filing a civil suit. You have to pay filing fees in the court. You might have to pay to bring in expert witnesses. There's your own legal fees in terms of paying your solicitors to look over documents, potentially paying a barrister to argue in court on your behalf. If you win, generally the other party will have to cover your legal fees, but it might not cover all costs. But the key thing is, what happens if you lose? Like, can you actually afford to lose? Because that's sometimes a risk as well. What if you go into it being like, well, I'm hinging everything on winning. I'm gambling everything I have on winning, because if I lose, I can't afford to pay this. The third consideration is the limitation of actions, and that's how long since the incident occurred. Basically, this is, as it says, there is a limit on how long you can wait to take action. There is a deadline. This changes for different disputes, but for something like personal injuries, which is the most common, sorry, that was meant to be an underline. For something like personal injuries, so the fact that someone's harmed you, which is the most common claim that goes through the courts, there is a 3-year limitation of actions. That means that if someone harms me, I can't decide to sue them 5 years down the track, because I had my chance and I've gone past that deadline. Some circumstances it's longer. I recommend you check out the Limitations of Actions Act, which lists effectively how long you have for certain disputes, and you can find that on OSLI. Consideration 4, scope of liability. And this is simply, how responsible is the person for your loss or harm? Like, how likely are you to succeed? Because this is where you've got to look at, okay, is this a clear-cut case that I'm definitely going to win and get some form of compensation? Or am I kind of pushing it uphill a little bit here? Is this going to be tough? Is there a chance I might lose? Is there a chance that the court might find it wasn't their fault? Naturally, you can't recover a remedy if the defendant did not cause the harm. Like, that makes sense. They shouldn't have to pay you if they didn't cause it. There needs to be a causal link between their actions and the harm that you suffered. And the key question here is, would the harm still have occurred without the defendant's actions? I've got a picture of lightning here, because a good way of perhaps understanding this is to think of a scenario where someone punches you and it knocks you out and you're under a tree. So picture that in your head. You've been knocked out and you're under a tree. While you're under that tree knocked out, a bolt of lightning strikes the tree and a branch falls off and hits you. What we mean by the scope of liability is the idea that if you sue that person, you can only sue them for the harm suffered from them punching you. You can't sue them for the harm suffered from the branch falling on you. Why? Because even though you wouldn't have been there without them punching you, the fact that you were there, the harm from the branch would have occurred without their actions. Okay? Therefore, it is not something that you can recover a remedy for. There is not a causal link between their actions and your harm. The causal link is the harm suffered from the punch. So that's a little bit of a further understanding perhaps of the scope of liability and how that works. Finally, and one of the big ones is enforcement issues. Is it worth going through the entire stress, financial burden, etc. of a legal dispute if the person can't actually pay? And this is genuinely a concern, particularly with the ability of organisations or individuals to move wealth around these days. What happens if you go through all this, you win, and then you get nothing for it? You go through all the stress of putting the dispute into the court system, of giving evidence, of bearing the financial burden of perhaps losing. You do win, and then they can't pay. This would suck. And is it worth pursuing a dispute if there's a chance that they can't pay? The court is able to try and enforce judgments. They can do this in a couple of ways if the defendant is unwilling to pay. One of these is what's called a garnishee order, and this is where they place basically a how would I put it? Well, an order, obviously, but the idea is that their employer, or through any other way they earn money, effectively, a portion of that is taken out of their pay and given directly to you. So it's almost like a payment plan in a way, but they're forced to give up some of their income in order to pay back or pay you the compensation or the remedy you deserve. An examination notice is a little bit further than this. This is where the court places an order to look at all of your assets, be it house, land, car, clothes, everything like that, computers, and basically make a register of how much you own or how much you are worth in terms of the assets you have. What can then happen is ultimately, if you won't pay, the court can put in place an order to seize your property and sell it in order to pay the plaintiff the money they're owed. So there are ways it can be enforced, but as a general rule, if they just don't have money, is it worth pursuing? So ultimately, to sum it up, before initiating a civil dispute, you need to think, can they pay? Is there a genuine complaint? Is there a time limit? Am I within my time limit? And can I afford it? And obviously, outside of that, can I negotiate? Can I avoid some of these things and negotiate instead? So skills, analyze the factors to consider when initiating civil claim. A little bit tricky, like this is a new area. This isn't in the old study design. So when we're looking at this, it's hard to, really understand what a question might look like. But in terms of looking at cases and case studies, my best guess would be something along the lines of this. Ignatius suffered a broken nose as a result of a brawl in a football match. The opponent who allegedly punched him is unemployed and claims that he didn't commit the act. Ignatius is considering initiating a civil claim to recover the costs. Outline what factors he would need to consider in this example. So what you'd be doing is looking at this and thinking, okay, factors to consider. Number one, can he pay? Take a bit from the case study. He's unemployed. So maybe here you'd be looking at, one factor that Ignatius would have to consider is whether the defendant can pay. In this instance, the defendant is unemployed, so he may not be able to pay. Any remedy that Ignatius recovers. Another one would be maybe negotiation options. Negotiation. In this, the defendant has claimed he didn't commit the act. So here might be a look at Ignatius going, you know what, and this is where costs come into it. You know what, it's going to be really costly to take this to the courts, especially as this guy is intending to defend the action. Perhaps we can look at negotiating. My lawyers can speak to his or to him directly, and we can come to some form of mutually beneficial arrangement where he pays a portion of my fees. Again, linking into the case study and making references to it wherever possible. The other ones to consider are limitation of actions. Has this, because it's personal injuries, occurred in the last 3 years? Would be one to consider. And also scope of liability. And in this case, that one would obviously be present because the punch has caused the harm. Evaluating the ability of the civil justice system to achieve the principles of justice. I'm a little bit distracted over the back here because the Australians have just lost lots of wickets in a very short period of time. Lost about 4-1 or 4-2. Nonetheless, does it achieve or not achieve fairness? Does it achieve or not achieve equality? Does it achieve or not achieve access? See if you can figure this out yourself, and we'll look at what I think in 3, 2, 1. Bang. So a little bit to work with here. Not much in terms of equality, but limitation of actions are equal for all similar offences. They're included in the Limitation of Actions Act. So this isn't one that changes for every different personal injuries claim. If it's one personal injuries claim or another, the limitation of actions is still the same. So that's equal. Where we look at maybe where it doesn't achieve the principles of justice is in fairness. If the other party can't pay, you can't receive restitution for the harm that you've suffered. That's it. Like, they can't pay, you're stuffed. That's not fair. You don't get justice. So that clearly doesn't meet the element of fairness. And we don't meet the element of access because due to the high cost of legal proceedings or the inability of the defendant to pay, you might not actually end up in the courtroom, and therefore you don't have access. But on the other hand, the negotiation options, such as mediation, etc., or just your own terms negotiated with the person, this removes the need for trial, this removes the need for expensive filing fees, expert witnesses, that sort of stuff. Therefore, negotiation options make accessing justice easier and also fairer, because as a result you can resolve your disputes in a way that suits both parties, in a way that suits you without worrying about them not paying, without worrying about them or without worrying about the cost to you, and as a result justice is served, and this is fair. So, applying these legal principles and information to actual or hypothetical scenarios, I've got only one for you here. This is a criminal dispute that could have been a civil dispute. So this is where a young girl unfortunately died on a ride at the Adelaide show. So it's not in the Victorian civil justice system, but still relevant. The owners of that ride were charged with some criminal offences around how they looked after the equipment, etc. And they were fined $157,000, and because they're declared bankrupt, it was found that they would have a criminal conviction recorded, etc., but couldn't actually pay the fine, so they wouldn't be able to pay the fine. So this is an example of where the family of that girl, even if they wanted to seek some form of compensation or remedy for her death and the harm caused as a result of that, there's really no point to them initiating a civil dispute, because we know that the defendant will not have the ability to pay. Is this fair? Probably not, but it's a reality of our civil justice system. So, in conclusion, and I think if I've got my timing right, just under my 20-minute mark, do we know the 5 factors to consider when initiating a civil claim? Negotiation options, costs, limitation of actions, the scope of liability, and enforcement issues. Hopefully you do. Hopefully you can explain all of these and answer that essential question: what are the factors an individual will need to consider before initiating a civil claim? This has been another video for the Legal Studies guy. Get those ratings in on Facebook, comments on the video on YouTube, etc. Feel free to drop me an email as well at thelegalstudiesguy@gmail.com. And yeah, happy studying.